fuck up what nobody says about none of that. I'm gonna be calling until my court date. They're not gonna do shit. At the end of the day, they can't do shit.
If he thinks we can't do something, you're going to look at this judge and think I can't do something, young man. You're going to learn a big lesson.
Court calls the case of the people versus Marquesi Hankey.
Your Honor.
Good afternoon, Your Honor. Attorney Kevin Hassan, except
Case item. All right, it's your motion.
I did file a motion to protect a previous PTC hearing. My client's bond vote from privileges from the jail suspended due to allegations that he cut off his tether and contacted the complainant. Following that particular bond hearing, I instructed my client to not contact the complainant with period in the jail. I also instructed my client that if allowed to be back on bond, we would ask the court to hopefully to reinstate his original bond tether. I would note that he has no prior criminal, well, no prior adult felony conviction whatsoever. Following the submission of my motion, I did read the people's response, which I guess there's been allegations that my client had contacted the complainant subsequently. Now, I just found out today some transcripts. Obviously, people address this. Some of the language that was used in our conversations, I don't have phone conversations myself, but I will admit, Judge, that it seems that my client had contacted the complainant even after his bond. And so I say this, Judge, again, I know it seems like my client is kind of throwing up his middle finger to the court.
Oh, yeah. Yes.
But Judge, I just would state that this young man.
The defendant openly claimed that nobody could stop him from making calls before his court date. His confidence was obvious, but the courtroom was about to remind him that ignoring court orders can have serious consequences.
I think he understands now that the court orders are serious, that the court orders him to do something, it means it. So Judge, I'm just asking, I guess, for some leniency to trust that Mr. Hankey will comply. He had a $75,000 cashier bond that he was able to post to a bondsman. The only thing I can ensure that if the court were to give him a second chance, he would not violate his bond, even if the bond is a house arrest with strict conditions. So Judge, I am asking the court to reinstate his bond, and if the court is unwilling to do so, I would at least ask that his phone privileges be allowed back on to at least contact family. Does he's never had any contact with his family, his children? He hasn't been able to contact his dad, caretaker for. And so at the very least, the restriction on his phone privileges to contact family.
All right. Well, before I hear from the people, counsel, let me just say, you came in here the first time, and well, let me start with this. Where's our tether?
From my understanding, Judge, I thought community corrections still had it. I thought they had become.
He cut the tether off. We haven't seen it.
Okay.
And I know you made the representation to the court, but I know you wouldn't have personally known that. I'm sure that came from your client or something along those lines. We don't have the tether back.
Okay.
Then, and I get you're making the representation saying your client's going to follow what the court says, but I don't know if anything can be as shocking as walking into a court free. Your bond gets revoked. You get put in.
His attorney asked the judge for another chance. He argued that the defendant now understood how serious the situation was and promised that he would follow the court's conditions. The attorney requested that his bond be reinstated or, at minimum, that he be allowed to use the phone to contact his family.
Jail because of something that you've done, and then you still go about violating the court's order.
I'll be honest with you, counsel. I mean, I get what you're saying. I don't have a problem giving people chances. I just don't know that this is the one to give a chance to. Because he just hasn't done anything the court's asked him to do. Ms. Senda.
Your Honor, I will rely mostly on emotion. However, in listening to his jail calls, he has 45 total calls to one number after his privileges were revoked with different pins he's using. Then to the other number, we have 23 calls that were completed since his privileges were revoked with different pins. And in one of these calls, as recently as Monday, there were a few memorable quotes that I heard in the calls, such as, "There's not shit in this world that's going to stop me from talking to you, man. Nothing in this world stopping me from you. I don't hook up what nobody says about none of that. I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit. I'm going to talk to you till I can't talk to you no more. I'll be home. I'm not worried, man. I know I told you this is about to be my last call, but I'm not stopping shit. I'm not stopping nothing." And then, why stop now if they already know? So I have extreme concerns that he cannot follow court orders, considering he cut off his tether, continued flagrantly calling the victim on other pins, both numbers, acknowledging in some of the calls that he should not be contacting her, and continue to contact her. He just cannot abide by any of the court orders that are set before him. So I have great concerns, and especially given the violent nature of this case as well.
Anything else, counsel?
I mean, counsel, does your client want me to just request to the jail that they put him in solitary so that he has no contact with anyone, can't use their PIN number?
The judge wasn't convinced. The court had already learned that the defendant allegedly removed his electronic tether and continued making prohibited calls. That history made it difficult for the judge to trust that he would suddenly follow the rules.
He thinks we can't do something, and if particularly you're going to look at this judge and think I can't do something, young man, you're going to learn a big lesson.
So I definitely don't want that. My client.
Well, he needs to, and I don't mean to interrupt you, counsel, but he needs to understand. You can say all that stuff. You are not that big, not that bad. Now, if you want to play with me, this is the kids say, mess around and find out. I guess that's not the quote, but it's close, but I did pretty good. I said it okay, right now. All right.
So just, if I may, just briefly, my client would like to.
Go ahead.
I want to apologize. I don't think I'm being bad at all. He is praising by my child. I can't say that I'm not in here for nothing. You obviously think I am. Yeah. I just want to apologize. Like I said, I'm not being bad. I don't want to be here at all. I really don't. Truly. Again, please show mercy. Please. That's all that matters.
I have no problem showing mercy to those that deserve it and have earned it. You have not. Motion for bond reduction or any change is denied. His bond will continue as revoked.
Thank you, Judge. And for the record, this is also, from my understanding, the PCC.
Yes, sir. Is all discovery complete?
And I would ask if possible, if possible.
The prosecution then presented evidence of numerous calls made after the defendant's phone privileges had been revoked. According to the prosecution, some calls showed that he knew he was prohibited from contacting the victim but continued doing so anyway.
People have their witnesses available on the first.
We'll do our best, Your Honor.
Preliminary examination in person will be set April 1st, 2025, 9 a.m. in person before Judge Perry.
And Your Honor, I did want to make it clear where I did contact the jail yesterday, and they have blocked both of victims' new numbers and old numbers, so there should not be any
More calls coming through. All right. Thank you.
Thank you very much, Judge.
Thank you, Your Honor.
Where are we on this, folks? Because,
I filed the proper paperwork.
well, I don't know that you did. Okay, so here's the problem. I don't think that I have subject matter jurisdiction over the case, and let me just explain it so everybody knows what I'm talking about. In order for the court to obtain subject matter jurisdiction over the case, I have to have a proper notice to quit.
when we were here, and I kind of explained it the last time that we were here. When we were here the last time, you were indicating to me that you gave them a notice to quit on the case. I didn't have it in my file. And I kept asking you, well, when did you serve it on them? Because I think they were saying they hadn't gotten a notice to quit. So I said that I had to have the one that has the proof of service on it, and I adjourned it out to give you an opportunity to correct that, because if it had been served, it was. So you filed with the court a notice to quit, and importantly, on the notice to quit that you filed, it says that they had to move by February 28th, 2025. And that you served it on.
The judge directly addressed the defendant's attitude. He warned that if the defendant believed the court couldn't do anything about his behavior, he was about to learn a very serious lesson. The judge made it clear that court orders are not suggestions.
On them March, as I'm looking at it here, March 10th, 2025 is what it looks like to me. And it says it's served by first class mail. Assuming this document to be true, I don't have jurisdiction over the case. And in fact, I'll just say this, this document, if that's the March 10th date, it can't be true, because you can't tell someone they have to move by the 28th of February and not give them notice that they have to move until March 10th. The only way that this notice, as it is signed by you, can make sense is if it were served on them on March 10th, they would have until April 11th or April 10th in which to move. So when I look at the face of the documents, this notice is invalid. With the dates that are on here, it can't be true.
Additionally, went with that notice to quit, had this file, had the police officer do it the correct way, because that's what I was told to do from this court. The notice to quit. You said that I had to show proper paperwork of me serving them the correct way. So the first time I served them was
And we went through this the last time. You gave me, and when you were talking about the police officer serving, that's the service of the summons and complaint. That I don't necessarily, as I'm looking.
Ultimately, the judge denied the request to reduce or change the bond. The bond remained revoked. The courtroom's message was clear: repeatedly ignoring court orders can destroy the court's trust and lead to serious consequences.